The Trump administration has released a proposed rule on public charge. This is a much anticipated rule. Earlier versions had been leaked to the media over the last several months, but finally the Department of Homeland Security has released the proposed rule, and the language is different than we earlier anticipated. Let's talk about what's in this proposed rule, then who it could potentially impact. This is the proposed rule that was released September 22nd. If that sounds weird, it is. That was late on a Saturday night that the Department of Homeland Security released the language of this rule. It's 447 pages. It is complicated. It is convoluted. And it's titled the Inadmissibility on Public Charge Grounds Proposed Rule. It essentially changes the definition of public charge. The current definition is very narrow. The feds almost never reject applications on those grounds, and this would instead expand the federal government's ability to deny visas or residency to immigrants. Public charge means you've been a burden on the American system in some way, and that's going to be used against you when you try to change your immigration status, when you try to become a permanent legal resident, if you try to go from a visa to more permanent status in the United States. Now, the language in here that is most damaging in this change definition is it would harm the ability of an immigrant to change their status if they benefited from non-cash assistance. And this is Medicaid, it's food assistance, it's housing assistance, and for immigrant senior citizens, it's Medicare Part D assistance. So this is quite cumbersome in how these benefits, which are envisioned to help people acclimate to a new land and to get healthy and to get food security and to get housing security, could now be used against them. Now, the biggest impact is anticipated to be to new arrivals, individuals seeking to immigrate to the United States to be with their families who may already be here. The new definition requires a broad evaluation of an immigrant's history and what they call their economic prospects. It gives wide discretion, and this is where it's also a little concerning, broad discretion to immigration officers to reject an immigrant's application for admission or legal permanent resident status. And this would include people on temporary visas. Like we said, this could be student visas, worker visas, or even DACA if someone is trying to file for permanent residency. So we're talking about a lot of potential impact here. Officers, those immigration officers with that broad discretion, can evaluate if an immigrant makes enough money to support their family, their discretion, or has resources to provide health care for a pre-existing condition. And they use a complicated formula to make this judgment call. They're looking at the types of benefits that immigrant family might be using, and they break that into two categories. Is this a monetized benefit, like a Section 8 housing voucher, or is it non-monetized? And they consider Medicaid to be a non-monetized public benefit. So they'll evaluate what kind of public benefit you're receiving. Then they're going to use a three-part test to determine duration of use and impact that you might potentially have on the United States. It's a complicated formula, and some advocates are saying this is looking more and more like the old-fashioned wealth tests we used to give to immigrants as they were trying to enter the United States. Someone would have a very strong, positive evaluation by an immigration officer if they were making over $62,750 a year. That would mean, nope, not a burden to the United States, come on in. So they're setting a dollar value, in essence, to who is welcome into the United States. And we make a little side note here that this is starting to look a lot like ancient history. We're really moving backwards when we start looking at wealth tests as opposed to more modern, progressive immigration policy. And we mentioned 1882. This was the year where the Immigration Act that was passed essentially put a $25 cover charge on entering the United States. If you had 25 bucks on hand, you could come in. If you didn't, you were turned away. Essentially, that meant that about 70 to 80% of immigrants were turned away up until 1920 from the United States. They couldn't pass the wealth test. Well, 1882 also stands out in our nation's history as a dark era where we had the Chinese Exclusion Act. We're starting to have immigration policy that's being drafted that's looking like those times have seen. How can we be more exclusionary? That language of public charge from 1882 as we move forward past 1920 into the 1950s actually started getting more lenient. We started seeing as a country that didn't reflect our priorities. It says on the Statute of Liberty, give us your tired, your poor, your huddled masses yearning to breathe free. It doesn't say how much money do you have on hand. In 1996, the test for public charge changed to more of a totality of circumstances test. We're going to evaluate more than just wealth factor and some of these other more harshly evaluated factors. We're going to do a totality of circumstances: family, health, employability, other factors that might be relevant. This was then clarified by Clinton in 1999 by what was called field guidance. It actually never codified into statute a true definition of public charge. It just gave a field guidance, a general sense to immigration officers of what would be appropriate to consider when looking at public charge. And that's really where we got the modern language that says, okay, if you're getting cash benefits, that might be something that we're going to evaluate a little bit more harshly than if you're getting non-cash benefits. But even so, very few immigrant families that even qualified for cash benefit assistance, so the number of people turned away because of that was actually really small, less than 3%. Let's fast forward. That was a little trip down memory lane through our nation's sometimes cloudy history of how we deal with immigrants at the border. The proposed rule would now force legal immigrants and those applying for immigration visas or legal permanent residency to either stop participating in public benefits altogether or risk being deemed a public charge, who is then ineligible for legal resident status. Now, the use of public benefits itself for these immigrant families coming in is not necessarily a turn you away factor. It's not an absolute, but it would weigh heavily as a negative factor for your application for either your immigration visa or your legal permanent residency status. The rule does also, and we made a quick reference to this before, the rule also consider certain health conditions. These immigration officers are going to evaluate if you have mental health disorders, heart disease, or cancer to be a factor that could weigh against you upon entry. And this is a statement out of the rule: at high risk of becoming a public charge if he or she has a medical condition and is unable to show evidence of unsubsidized health insurance. Ironic that we would also use Medicaid or Medicare Part D against a person when we really want them to have health insurance and show that they're healthy. Now, I underlined the word unsubsidized here. In the previous draft leaked versions of this rule, marketplace tax subsidies would have been used against an immigrant family. In this new proposed rule version that was released, that is not the case. If you do have a little bit higher income, can buy health insurance on the marketplace, which most immigrant families can if you're lawfully present, and that includes student visas, worker visas. If you're lawfully present and can buy a marketplace plan, you could qualify for tax subsidies. Well, that will not be used against you in your immigrant application because the reasoning here, as you can anticipate, looks more at income. And if you can afford that, your little bit higher income won't be used against you. That's the rationale as it stands right now. Now, there are people this does not impact. This does not directly target immigrants who have already been legal permanent residents with their status. It does not apply to refugees or asylees at all. It does not apply to legal immigrants who serve in the military, and there is also, and this is the big thing to keep in mind, there is no penalty for those who have used benefits before this rule goes into effect. So before the effective date of this rule, this policy should not be used against you. If you use Section 8 housing, if you use food assistance before this date goes into effect and you are an immigrant that is looking to then stay permanently, public charge cannot be used against you. It is only from the day of effective date moving forward. The devil's going to be in the detail for getting that messaging out to families, and we're going to talk about broader impact in just a second. And again, this only looks at benefits an immigrant is getting for himself or herself, not for other household members. And this again is a change from the earlier leaked versions of this proposed rule. This means if we have an immigrant mother who has a U.S. citizen child and the U.S. citizen child is getting Badger Care Plus, Medicaid, food share, the fact that the child is getting benefits cannot be used against the mother. It only looks at each person and what that person is receiving, and therefore what their application for immigrant status might look like. So that's a change. Before it was looking at members of the household. Now it's looking at each individual person and the benefits they use themselves. Again, messaging is going to be important. The feds have estimated that about 382,000 green card applications are submitted each year. Just over 500,000 for other visa applications are submitted, and therefore those people are potentially going to be impacted by this new rule. So they're saying under 1 million people potentially impacted by this new rule. They're saying it's actually hard to pinpoint the whole impact because of that discretion of immigration officers language, where it could actually be quite broad, or they could use their discretion, it could be quite narrow. So the direct impact is going to be hard to measure, is what the feds are telling us right now. We know it should not be on people already here, more so for people looking to seek permanent immigration status in the United States. So moving forward in time, people coming to the United States. However, the indirect impact could be up in the tens of millions of people, mostly because of those very specific, complex wording in the language itself. Kaiser Family Foundation estimates about 20 million children in immigrant families could be impacted, 90% of which are U.S. citizens, mostly because of that language that says this attaches to the individual themselves, not the families. People aren't going to know that. The impact is, it could be just from chill factor alone. The regulation is complex. It's not an automatic disqualification. You have to go through an evaluation. You get discretion of an immigration officer. But just the conversation itself is chilling. Advocates suspect that many legal permanent residents, refugees, asylees, and U.S. citizens will just stop using public benefits, thinking that's the impact of this proposed rule. That's a terribly broad impact that could impact tens of millions of people. Now, we have seen this before. I mean, not only our dark history in the 1800s coming into early 1900s, we've seen this in 1996 when welfare reform legislation was passed. Similarly, not impacting directly refugees or asylees, but yet 50% of refugees and asylees receiving health care assistance stopped getting their health care assistance because they thought the rule applied to them, and it did not. We saw that with U.S. citizen children of immigrant families. We also saw that with legal permanent residents who weren't directly impacted by specific language in that rule, stopping getting housing assistance and food assistance. So the fact that this is a rule and it's complex and families aren't going to know if it applies to them or not is going to mean a chilling effect for people actually signing up for benefits of any kind. This could also be in the very minute details. Say there's a clinic that has a free vaccination day. Families aren't going to know if that counts against them for this public charge rule or if it doesn't. So just the confusion factor alone is a chilling effect. We've seen it before. That should be instructive enough to know that this should not be applied in this manner. But maybe that's the point. This administration has been very clear on securing its borders, whatever that looks like, of making sure that we're much stricter with the immigration rules that we have, and with also trying to restrict eligibility for Medicaid and other public benefits programs, thereby saving money, and this is proposed to save billions of dollars overall. Next steps and what you can do. The rule was released as a proposed rule from the Department of Homeland Security. It next gets published in the Federal Register as a proposed rule, which starts the clock ticking on a 60-day public comment period. Your action step, if you like this rule, if you don't like this rule, you can submit public comment. It can be as simple as an email, and we'll have a separate video on specifically how to submit comments on this proposed rule. When 60 days elapses, the feds have time to look at those comments, hopefully take them into account, and issue a revised rule and make some revisions overall. That will be published in the form of a final rule, which will be effective 60 days after publication. So we've got time. This is not effective right now. It was released. We're watching for publication in the Federal Register. We can then issue public comments. The feds will then issue a final rule. It'll be effective 60 days after final rule. So we're looking into 2019 if this gets published as a final rule. What should we expect if this is indeed published as a final rule? Advocacy groups and immigrant rights centers have already promised that they will fight this language in the courts. And this will be, the rules as just conflicting. When you have Medicaid rules and housing and food security that are established as entitlement programs, and then you have a rule, an administrative rule that doesn't work its way through the Congress, that just comes through administrative rulemaking that restricts that entitlement, there will be litigation that follows. You can read the proposed rule in its entirety as released by the Department of Homeland Security. There are some really great articles out there that have already been written on this proposed rule. We share the link to those. You can read up on them. The Vox article is great. It goes even into more detail on our history of dealing with immigration and how we've been more restrictive in the past and how it appears we are coming full circle to those dark ages of the 1880s. You can share your healthcare story. What would it mean to have this proposed rule become a final rule? What will it mean for the families you work with? You can tell us your story. You can ask a question, send us an email, and you can do all of that at healthwatchwisconsin.org.